Okay, yeah, you hear me? There, okay, yeah, good. So the conversation had already started indeed. My name is Emmenegger, Professor of Public International at Utrecht University, and one of the co-organizers. Welcome to the panel on jurisdiction. Jurisdiction, of course, being an important legal question. We touched upon this in relation to secondary sanctions, because these sanctions may have, as you know, an extraterritorial dimension, and they tend to regulate relationships between parties located outside the sanctioned sender's territory. And under international law, this may be presumptively suspect, unless perhaps there is a genuine connection between the subject matter person and the sender. Is there? Question mark. I think that's one of the key questions for this panel. We have three, or I might say four, excellent speakers. In fact, all joining online. I'm the only one joining on campus. We have Patrick Terry from Kehl University College in Germany, who's going to speak about access restrictions. We have Susan Emmenegger, and I think also Florence Zuber, who might take the floor from Bern University on dollar-based jurisdiction and correspondent bank accounts, something we've already touched upon earlier today. And then finally, we have Bill Dodge from the University of California, Davis in the United States, who will talk about the role of US courts regarding challenges to secondary sanctions. Each of our presenters have between 15 and 20 minutes. This will be back-to-back presentations, and then we will have a Q&A, which will be moderated by me from here. And I'm sure this is going to work out. I think, Patrick, you're first on the list, if I'm correct. Yeah. So I will stop screen sharing, and then you have the opportunity to share your screen if you want.
Yes, thanks. I trust you see the screen, hopefully. Thank you very much for the introduction, and thank you for allowing me to participate in your conference. And of course, I'd have much preferred to be in Ghent, but due to the situation in Germany and in Belgium, that wasn't possible. Our university has prohibited all travel abroad to the end of January. So it's not possible for me to attend in person. I'll be talking about secondary sanctions, access and jurisdiction, a very large topic, and due to time constraints, I can only address some of the more controversial aspects of that topic, and I will of course be focusing on United States secondary sanctions. So how does the United States attempt to enforce its sanctions? Basically, there are four categories. That is the prohibition of entry into the US of foreign sanction evaders. Then the sanctioned individual is cut off from the US commercial and financial systems. And then the two other more far-reaching consequences, which are more recent, is the imposition of fines. As we heard this morning already, BNP Paribas was fined 8.9 billion in 2014 for violating sanctions on Sudan, Libya, and Iran. Deutsche Bank was fined $258 million in 2015 for violating sanctions on Iran, Libya, Syria, Sudan, and Burma. And other banks such as HSBC have been targeted as well. And more recently, of course, we now have the arrest and imprisonment of foreign sanction evaders. Two more prominent cases. Susan has gone into that in some detail. One of the cases I'm going to mention, which is Reza Sarrab, a Turkish resident of Turkey who was arrested in the United States when on holidays in Florida, based on the fact that he was involved in a complicated scheme to enable Iran to access Turkish payments for gas deliveries. And because at some point US correspondent banks were involved in that complicated transaction, he was seen as a foreign sanction evader. There were also other violations, which I won't mention now, but basically he was acting in accordance with the laws of Turkey, Iran, and the United Emirates. That was also part of that transaction. At the same time, and more recently, we've had the very controversial case of Meng Wanzhou, Huawei's chief financial officer, who was arrested in Canada in late 2018 based on a US warrant. And she was accused of fraud by the United States based on the claim that she had misrepresented the relationship between Huawei and a Hong Kong-based company called Skycom. Skycom was accused of having sold mobile phone equipment produced in the United States to Iran. Because she had not been open about this relationship, the United States claimed Skycom was a subsidiary of Huawei. She had been then able to access monies that were cleared in the United States. And therefore, in the view of the United States, she was guilty of fraud. Now, based on that extremely far-reaching interpretation of the United States right to enforce the sanctions, one has to ask, is that in accordance with international law? And that raises the issue, as Cedric already said, of jurisdiction. Now, there are 6 possible principles of jurisdiction that could be invoked in order to justify the regulation of conduct that takes place abroad. I will only be going into the 4 more relevant principles. I don't think anybody seriously contends that US sanction laws are justified by the passive personality principle or the universality principle. So I'll just be looking at the first 4: territorial, effects, protective, and active personality principle. Now, the most controversial issue, I would say, is the issue of the territorial and active personality jurisdiction. Now, territorial jurisdiction, of course, enables a state to exert jurisdiction when conduct takes place on its territory, or a substantial part of that conduct takes part on its territory. That's uncontroversial, basically. Similarly, the active personality principle, the right of a state to exert its jurisdiction over its nationals, even if they are acting abroad. However, I should add at this point that the way the United States applies the active personality principle is generally rejected by the international community in 2 instances, and that is, first of all, its tendency to ascribe nationality to products produced in the United States, and therefore the United States asserts the right to prohibit the re-export of goods originating in the United States to primary sanction targets. As far as it applies the active personality principle to legal persons under US control, because the international community generally assumes that the nationality of a legal person is determined by its headquarters or by the laws under which it is organized, also based on what the ICJ had to say in the Barcelona traction case. But the most controversial issue is whether the United States is justified in imposing entry bans and denying access to its commercial and financial markets based on territorial and active personality principle. And there are some who say that is the case. It is justified by territorial and active personality principle because basically the United States is regulating the behavior of US persons who are prohibited from engaging in business transactions with foreign sanction evaders. Jeffrey Meyer's article in 2009 was very influential in that respect, and he called that or referred to it as a terri-national jurisdiction. However, I do not agree with that view because in my view, US secondary sanctions, and in that context, the entry bans and the denial of access to financial and commercial markets is not about prescribing US citizens or persons' behavior, but it's about enforcing sanction laws that target foreign persons acting abroad. And if it is an enforcement action, as I see it, then the question is whether the underlying law that's being enforced is justified by a jurisdictional principle. And of course, in that context, regulating the behavior of foreign persons acting abroad, that would certainly not be justified under territorial or active personality principles. Now, why do I view it as an enforcement action and not as a prescriptive rule? Simply by taking the US regulations by their word. So, and I'll be quoting a few things. If we look at Executive Order 13608, that deals with foreign sanction evaders in respect to Iran and Syria, Section 1 states, the Secretary of Treasury, in consultation with the Secretary of State, is hereby authorized to impose on a foreign person the measures described in subsection B of this section upon determining that the foreign person, and then we have a list of sanction evasions. Similarly, if we look at the website of the Department of the Treasury at their frequently asked questions section, the Department of the Treasury states, the executive, and I quote, Executive Order number 13608 expands Treasury's ability to address the behavior of foreign persons determined to have violated or attempted to violate US sanctions on Syria and Iran. So again, the US itself sees these actions, which include entry bans and the denial of access to financial and commercial markets, as enforcement. And lastly, the last quote, I promise, in that context, if we look at the Iran and Libya Sanctions Act of 1996, the act itself describes itself as an act to impose sanctions on persons making certain investments directly and significantly contributing to the enhancement of the ability of Iran or Libya to develop its petroleum resources. So all these regulations and legal texts imply that the United States itself views these actions, including the entry bans and the denial of access to financial and commercial markets, as enforcement of its sanction laws, and therefore not as primarily regulating behavior of US persons on US territory. Moving on to the other two more relevant jurisdictional principles, effects and protective principle. The effects principle states that a state can exert its jurisdiction if a transaction taking place abroad has direct and substantial effects on the state exerting its jurisdiction. Now, based on that, if we just look at two examples, the US sanction laws cannot be justified. The sale of goods originating in the United States from a third state to a primary sanctions target state has no effects on the United States. And for example, if we look at the sale of mobile phone equipment from Hong Kong to Iran, even if it was originally produced in the United States, does not have a sufficient connection to the United States. Similarly, in my view, the transaction between two correspondent banks in the United States does not have the necessary substantial effect on US territory if the commercial transaction takes place abroad. And the Reza Sarab case is an example. The complicated transactions took place exclusively in Turkey, Iran, and the United Arab Emirates. And only because some of these foreign banks had US subsidiaries and used that in order to clear the monies did the US claim jurisdiction. As far as the protective principle is concerned, which states that a state can exert its jurisdiction if there is a substantial threat to its national security. First of all, it needs to be pointed out that the mere claim that its national security is threatened is not sufficient. As the ICJ pointed out in the Nicaragua case in 1984, when the United States claimed that the actions Nicaragua had undertaken had threatened its national security, the ICJ made clear that a state has to elaborate in what way and which specific action threatened its national security. And if we look at the example of Cuba, for example, I don't think anybody would really seriously consider Cuba as a substantial threat to the United States national security. And furthermore, this principle can only apply towards specific transactions that threaten a state's national security, and not the kind of blanket ban we see in the United States secondary sanctions, such as, for example, the sale of mobile phone equipment from Hong Kong to Iran. So in summary, I would say that none of the recognized principles of customary international law as far as jurisdiction are concerned justify US secondary sanctions. But I would go on to say that even if you disagree with me, by now, and that may be changing again, but by now there is a customary international law prohibition. And why do I see that? Because states have simply, when addressing US secondary sanctions, not differentiated between US entry prohibitions and the denial of access to US commercial and financial markets on the one hand, and the imposition of fines or imprisonment on the other hand. When states have addressed US secondary sanctions, they have sort of expressed a blanket condemnation as unlawful under international law, and they have not made that distinction. In fact, Jeffrey Meyer, who in 2009 wrote this article I referred to earlier, he laments that in his article. He says that the conventional view is that there is no difference and that scholars and states have not made that difference, although he sees it as necessary to make that difference, but it is simply not happened so far. And we've had the individual states like Austria and Germany issuing a statement in 2017 in respect of the Nord Stream 2 sanctions, condemning that as a violation of international law. We have a statement by the European Union in 2017, similar. The Group of 77 has issued statements on this topic, and it comprises 134 member states. The UN General Assembly has passed numerous resolutions on Cuba since 1992, specifically referring to the extraterritorial effects of US sanctions, always passed by overwhelming majorities. The most interesting thing is to look at the United States' reaction when confronted by secondary sanctions. And looking into the discussions that took place in the United States in the 1970s, as far as the Arab boycott is concerned, one sees that very similar arguments were made to those I've just made. The Arab boycott, of course, was a measure to bar American businesses, among others, American businesses from doing business in Arab states if they are commercially engaged with Israel. And during these discussions, we had, and now I'm quoting again, the US Secretary of State, Cyrus Vance, declaring, and I quote, that decisions as to what commerce US firms may or may not have with other countries or with other US firms should be made consonant with American policy by Americans and only Americans. He went on to emphasize the United States, and I quote, right to regulate through our laws the activities of our citizens. And the Senate committee report on the amendments to the Export Administration Act that dealt with the Arab boycott concluded that the United States should not acquiesce in attempts by foreign governments through secondary or tertiary boycotts to embroil American citizens in their battles against others. So basically the arguments, without expressly stressing that it was unlawful under international law, but the arguments point in that direction. And that led Henry Steiner, who at the time published an article summarizing all these arguments in the United States as to the Arab boycott. And he, in fact, summarized them as follows. He said there were those who wanted to take measures against the Arab boycott, and they made legal arguments based on a violation of the US sovereignty. And those opposed to taking measures against the Arab boycott, whom he claimed only made political arguments about loss of US influence in the Middle East. So that's how he interpreted the discussion in the United States. And I'm pretty certain that if, the speaker from the Deutsche Bank this morning mentioned that if China started to impose secondary sanctions, for example, involving Taiwan, I'm pretty certain that the United States would take the view that that was unlawful under international law. And my last slide, I'd just like to point out, it's not really my topic, but I think other rules of international law are implicated by secondary sanctions. I think it's very likely that the way secondary sanctions are being implemented is a violation of the prohibition on interventions in the internal affairs of other states and violate the principle of sovereign equality. And some have argued that it is also, I'm sorry about that now. And others have argued that, I'm sorry, that this is an abuse of rights, mainly those scholars who have argued that the imposition of entry bans and the denial of access to financial and commercial markets are lawful under territorial principles, have gone on to argue or indicate that they believe that the US is guilty of an abuse of rights in that respect. For example, Von Lowe, who argued that these measures were justified under jurisdictional principles, went on to say, but the United States is using these rights for objectionable reasons. So he seems to indicate that he views the invocation of these rights as an abuse of rights. And there I would end my presentation. Thank you very much.
Okay, so hello everyone. I'm going to try to share my screen. Okay, I think, can everybody see that and everybody hear me? Can I go ahead? Okay. Well, hello everyone. Thanks, Patrick, for your perfect introduction to my topic. My topic is US Correspondent Account Jurisdiction. That was the original title, and it might be interesting that Tom or Cedric changed it to currency-based jurisdiction. So I'm not sure if Tom and Cedric, you're a step ahead of me. Is that what it's going to be? Is it that already, or is it not? We have heard Martin this morning who said, well, we should be careful. It's not really the currency. That's not even the opinion of the Treasury Department of the United States. It is really the person, the US person who is involved. Now, we might both be right in the sense that, and that's going to be one of my questions, is there ever a US dollar transaction without a US person involved? If we look at the practice of OFAC and the DOJ and so on. So that's going to be one of the questions I'm asking. So I'm going to look at the significance of correspondent account jurisdiction. I'm going to be very brief on that because Patrick has mentioned all the important points. And then I want to look with you at what is actually correspondent account jurisdiction in action? What, how far has it extended? And then really the question, well, can we do something about it? Can that US jurisdiction be legally avoided if we look at the cases and how the territoriality principle is interpreted by the US authorities? And by this, I'll also say, even though I've written about the legality or illegality of correspondent account jurisdiction or currency-based jurisdiction, it's not something I'm going to address today. Bill is going to be doing such an absolutely wonderful job on this that I will not. And Patrick has done the international realm. So I think I fit into this perfectly, because what I want to really look at is, what does that mean in practice? How far did it go? How far did it go so far in jurisdiction? I'm starting with the significance, and I can be brief because all the cases that you see here have been mentioned this morning and by Patrick again. So we have the corporate victims or offenders, depending on how you see it, banks who have transacted with sanctioned entities like BNP Paribas. We've had people being put in jail. Reza Zarrab is a case, Mehmet Attila is a case, and Meng Wanzhou is a case. So these people have felt the whole wrath of US sanctions law sort of in person. And so, if we look at Meng Wanzhou, she was greeted in China like an astronaut returning from a far planet. Mehmet Hakan Attila is now head of the Istanbul Stock Exchange. So there's definitely a different view on what these people did. For the US, they're criminals. For their home country, they are heroes. So what are we even talking about when we talk about correspondent account jurisdiction? Now, what we really need to understand is, and I'm not sure if you can see my pointer when I point, but can you see that? Okay, so let's start with a simple transaction. And Martin has done this already, but it's, I think, really important to realize this. If we have anyone, a French citizen, client of a French bank, sending money to a business partner in Turkey, if it's US dollars, there's really no direct way to do this. His bank is going to have to go through a correspondent bank in the United States, going through the US payment system, which is either Fedwire, CHIP, ACH, and his Turkish business partner will have a Turkish bank, and they will also have an account or a subsidiary, it doesn't matter, but it's always a correspondent bank here that will take this money and then credit it to this account. So this US payment system is sort of the overarching jurisdictional nexus that we should keep in mind. And it is exactly this weapon, if we want, so that makes the sanctions system of the United States, at least from a US point of view, very effective. And in the DOJ statement on Meng Wanzhou, we can read this: financial institutions are our first line of defense in maintaining the safety and security of the US financial system. And one should add, in view of the compliance with US sanctions law. So this is really I think the biggest instrument and most effective instrument to enforce unilateral sanctions on a multilateral basis. This forced multilateralism that we have heard mentioned this morning, that's, I think, that's what we're talking about when we talk about US correspondent account jurisdiction, or maybe one should just say the jurisdiction based on the use of the US financial system. It doesn't sound so nice, but this is what it's all about. And what I want to look at is, so how does this work? And we can really distinguish between sort of direct transactions involving the US financial system, and that's where really the extension starts with what the US authorities call correlated transaction involving the US financial system. And we have a number of instances where these correlations have led to assertion of jurisdiction by US authorities. And then we have some special cases, foreign exchange transaction in non-US dollars. They are also correlated transaction, but they're so special, I put them sort of on a different level because they're even, for me, one level further down. And then we have the Huawei case, which really we have, it's very hard to even see a territorial connection, but where this territorial connection was asserted. So if we look at the sort of the basic jurisdictional claim by US authorities is, if you use the payment system, but you don't tell them that you're doing this for a sanctioned entity. And really, if we want to believe the Swiss financial supervisor, the first case was TBC Lloyd's in 2007, where this as an only connection was deemed sufficient to actually assert jurisdiction. There were about 3 or 4 cases at the same time. Credit Suisse was one, New Zealand Bank, Australian Bank was one, ABN AMRO was one. So, but there was a whole group where this started, where they started to say, if you lie about who you're doing, or if you're not lying, if you just omit the sanctioned entity and you prevent the US correspondent from blocking this transaction, we're going to hold you liable. So that was really the first one. And so banks, first of all, not being shy, but also looking at this from a unilateral sanctions point of view, try to move away from this connection. And this looks like a complicated slide, but it's not so complicated actually at the end. So one way they tried to do this, and BNP Paribas was actually a case, and also the British Arab Commercial Bank, is to say, well, we're not going to just transact for our sanctioned client. We're going to put a bank in between. That's the satellite bank system. And it really starts down here. If you have a bank in London like BACB, and they have a sanctioned client, what they did and what they could do, or what they thought they could do, is they could say, well, we go to a third bank, BNBP Geneva, and we're both going to be clients there. And this is going to allow us to transact, so, to make the client invisible, because if this client wants to send money, he's just going to transfer this amount internally to BACB London account. And then when Geneva sends the money, it's going to be on behalf of BACB London, and it's going to go through the system, and it's going to go fine. If somebody wants to send money, they're going to send it to BNBP Geneva on behalf of BACB London, and it's going to be in this first account here, and then it can be transferred to the sanctioned client, and the sanctioned client becomes invisible. And you can say, well, this is really circumventing the sanction system, but you can also say, we're moving away from the US. We're putting another bank in between, and this should be enough. Of course, we all know this got the stamp of of the US authorities saying, no way, Jose, this is not going to be possible. So, and we know about the fines that were being paid. $8.9 billion still rings in our ears. So the next step was to move even further away, to say, we're going to have to create a system where the whole system is outside the United States. And this was actually also the example of British Arab Commercial Bank and a Bank B, non-disclosed, presumably a Chinese bank, because it regarded Sudan. And the idea was that this Chinese or other bank would open accounts for all the interested parties who were doing business with Sudan, and creating sort of a closed circuit where all these bookings could work internally. So we're really far away from the United States now. We're presumably in China, with people having, or banks and companies having accounts there. Whenever you had a dollar payment, you could move this dollar payment internally. So totally internal clearing. So why did BACB have to sign a settlement with the US authorities? Well, because now and then they needed funding for this account, the BACB account at Bank B. And this funding here happened first through a US bank, but later on through European banks. So BACB had a dollar account, several European banks, and told these European banks, please send it to Bank B. And what happened is, and they had no decision in how this money gets there. But guess what? They went through the US correspondent banking system. And so this was enough of a link from the view of the United States authorities to say, you indirectly exported services from the United States, and therefore we hold you responsible, and we hold you to be part of our territorial jurisdiction. So if you think this is already far away, let me move to the next example. Back-to-back letters of credit, complicated matter, but to make it short, a letter of credit is a guarantee that a bank will give or issue on behalf of a company who's buying goods. And the bank will guarantee to the seller that the payment will arrive if the goods arrive. That's basically a letter of credit. So what happened here is that Union de Banque Arabe in Paris issued such a letter for a sanctioned entity. I think it was a Sudanese or Syrian entity. And it issued a letter of credit, but not in US dollar, presumably in euro. So nothing to do with the United States, issued for a seller somewhere outside the United States, not in US dollar, for an entity unilaterally sanctioned by the United States. The problem was, at least for UBAF, that it was a back-to-back letter of credit. Sometimes the intermediary here needs a letter of credit because he himself, this company himself, will buy goods from another one, selling it then to the sanctioned entity. And this intermediary used the same letter of credit, but changed it basically, or used the second one, but a relating one, but changed it to US dollars. So for the US authorities, enough to say, well, you're using the US financial system because it is a connected transaction which happened in US dollar. So if that happens, we have enough of a connection. We don't regard your letter. So basically what it tells the bank is, you don't only have to look at your contracting party, you have to know what your contracting party is doing with another contracting party. Know your customer's customer. That's basically the jurisdictional link used here. And if you think that's not enough, well, US jurisdiction can also happen when you don't do anything with US dollars. So that's why currency-based won't even work. It's not even a US dollar jurisdiction. Pour Union de Banque Arabe et Française was involved in a Forex transaction. What's that? It means that you buy a foreign currency. So UBAF had a client, and this client had a non-USD account. We don't know which one because it's a settlement, and so we don't know, but let's say this client has an account in British pounds, and this client has an account in euro. So internally, euros were moved to British pounds. No US involvement for sure. But then UBF Paris exchanged these British pounds, or a part of it, for Hong Kong dollars, non-US. Nothing US in here. So where's the nexus? The nexus is because these foreign currencies were cleared in the US. And how can that be? Well, one of the world's largest international payment system is based in New York. So presumably it was a CLS clearing. And if not, it could still have been New York because Forex is just a big electronic market and it can clear anywhere. And depending on the time frame you're using, it may be in New York. So that's enough for US authorities to claim jurisdiction. And this is Huawei. Now, Huawei is difficult to explain, really, from a jurisdictional point of view. Patrick has already tried. I'll give it another try, Patrick. I'm not sure if, but here we have Huawei, a Chinese company who operates a subsidiary or who owns a subsidiary, and this subsidiary does operations in New York. Both have an account, not in the United States, with HSBC Hong Kong. And what is alleged is that Skycom used its Hong Kong account to transfer US dollars. And by now we understand that the standard transition is always through the US payment system to a US correspondent bank. And one of these payments, 7.5 million, that's the only one we know for sure, went to a US bank where a UK staffing company active in Iran had an account and was sort of acting for Skycom in hiring Iranian engineers. Whether the rest of the 92.5 million were really sanctions related, we don't know. It's quite vague in the settlement. So in the deferred prosecution letter. So we don't know. But this is the way it went. And so what did Meng do? Meng was arrested in 2018. In 2013, 5 years before, she had misrepresented the relationship between Huawei and Skycom, saying that's a normal business relationship where Huawei is in strict compliance with US law vis-a-vis HSBC Hong Kong, vis-a-vis an executive in Hong Kong. So we have a Chinese executive making a statement to a Hong Kong executive in Hong Kong about a business relationship with a Hong Kong company. What did the DOJ say? the failure to tell the truth about Huawei's indirect operations in Iran caused HSBC to continue to do business with Huawei in violation of US law because Huawei is held responsible for Skycom. So you made HSBC violate US law by not telling them that you have a subsidiary. So this is, I think, the furthest away so far from what we've seen in territorial connection. So why? Can we go anywhere else? We had this question before. Can we go anywhere else? And I guess the short answer is no. And what we have to understand when we look at the US payment system and the dollar payment system is that all these payment systems that I've mentioned, Fedwire, CHIPS, even ACH, they require, if you want to participate in that system, you're required to have a local presence. So you have a local presence and you have a national single currency. And all these payment systems operate in that way. That's not something that only the US does. That's everyone. And so if we look at the Euro payment system, it's the same. You cannot participate in the target's payment system if you're not a bank with a location or at least a branch in the European Union. It's the same for Switzerland, it's the same for everywhere. You need to be incorporated or at least present there. Otherwise, you cannot connect to that system. And that creates a territorial link in the first place. And so if you're the US, you can, of course, regulate your US banks. And other banks will not be able to come in except through a US bank. You cannot leapfrog into the system. You have to go through a US bank. And so, of course, the question becomes, well, why doesn't the ECB just operate a dollar system? Why doesn't anybody do that? Well, the answer is it would be to operate a large-scale payment system is hugely complex, hugely costly, and you need huge currency reserves. Nobody can do that. And even if you try, the ECB, no central bank has this mandate. Each central bank is worried enough about keeping the monetary stability for their currency. They cannot operate another system. And if they did, that's a sovereignty, an attack of the monetary sovereignty of the US. That's why we see such a big pushback against Libra projects, DM projects, any kind of digital currency that will put into question the monetary sovereignty of central banks. And so you cannot operate a system outside the United States. So you need this correspondent banking system. Now, we do know, and it's been mentioned today, but there are offshore payment systems. Tokyo, the Philippines, Hong Kong, Singapore, they exist. So is that the alternative? And my answer is no, it's not. Singapore does only checks, and they're settled by Citibank. That's a US bank. So you don't evade sanctions by going to Singapore. Tokyo is operated by JP Morgan. You will not avoid US sanctions by going through Tokyo. The Philippines are operated by Citibanks, and Hong Kong, the Hong Kong one, we have heard by Albert Zubin, the US Treasury at some hearings, but also statements in the Canadian court that non-US bank could utilize the clearinghouse automatic transfer system chats in Hong Kong. And that would avoid the US financial system altogether. And the argument was made in the Meng Wanzhou case. She had no say in where this was going to be cleared and settled when she or the company controlled by Huawei, made dollar transfers. It could have gone through Hong Kong, but it's not the case. See, the chats liquidity is provided by HSBC's account with the Federal Reserve in New York. So chats transaction in US dollars ultimately settle in the books of HSBC New York. So you're back into the territorial connection. And this is my last slide. US correspondent account jurisdiction to infinity and beyond. I think that, you know, there are no practical ways to avoid territorial jurisdiction as it is interpreted today by US authorities. And yes, I have written that I think that this violates international law, and I still maintain this. But from a practical point of view, and I was interested in looking at these payment systems and thinking, well, why doesn't just anybody do something else? And I have to say, well, there is no really something, there is nothing else. This is really it. And maybe challenges by US law will help. And we're going to be happy to hear Bill Dodge talk about this if challenges in US courts will have a chance of success. And that's my presentation. And thank you very much for listening. Let me stop the screen. Okay.
Great. Well, I will pick it up there. And thank you, Susan, for that segue. Greetings from California, where it's rather early in the day. I want to thank Tom and Cedric for inviting me to participate in this great conference. I'm going to not share my screen and see if I can explain what I have to explain without the help of slides. I'm going to discuss possible challenges to US sanctions in US courts. There have not been many of these challenges so far, and that's in large part because the denial of access to the US financial market, which Patrick Terry was discussing, is such a powerful enforcement tool that most banks will simply settle the US charges in order to maintain access. But there have been some challenges to US sanctions in the prosecutions involving Halkbank, as has been mentioned several times. There have been 3 prosecutions. The first was against Reza Zarrab, who unsuccessfully challenged the US sanctions as impermissibly extraterritorial and then pleaded guilty. The second was against Mehmet Hakan Atilla, Halkbank's deputy general manager, who was convicted and sentenced to 32 months in prison. And the third is against Halkbank itself. And recently, the Second Circuit concluded that Halkbank is not entitled to immunity under the US Foreign Sovereign Immunities Act. And so I presume that case will now proceed to trial. The central charge in each of these cases has been the violation of US sanctions against Iran. The US International Emergency Economic Powers Act, a statute that's generally known as IEPA after its initials, gives the president authority to regulate certain financial transactions by any person or involving any property subject to the jurisdiction of the United States. The Iran sanctions regulations in turn prohibit the exportation of services to Iran, which include banking services in the form of clearing transactions. Halkbank and Zarrab and Atilla were charged with violating these sanctions by arranging transactions for Iran that would be cleared in the United States. The defendants were also charged with defrauding the United States by obstructing its lawful functions, specifically its function of enforcing US sanctions. They were charged with bank fraud for concealing the Iran connections from the US banks that were involved in clearing the transactions. And they were charged with money laundering, with the unlawful activity being the violation of US sanctions and the bank fraud. The district court's analysis of extraterritoriality in each of these cases has, in my view, been inadequate. In its most recent decisions, the court has simply said that because there is a sufficient nexus to the United States, there's simply no question of extraterritoriality. And that reasoning doesn't address the relevant questions under either US domestic law or international law. So in the time that I have, I would like to address those questions. First, I will discuss how the US presumption against extraterritoriality applies. And second, I will analyze the legality of the sanctions under customary international law, and then discuss the implications of that analysis with respect to US law. The US presumption against extraterritoriality is a canon of statutory interpretation, and it's the principal tool the US courts use to determine the geographic scope of federal statutes. There are two steps to this analysis. There's a clear indication step and a focus step. So at the first step, a court will ask whether a statutory provision gives a clear indication of its geographic scope. If it does, that is simply the end of the analysis. The court will apply the provision as Congress has indicated. Second, if there is not a clear indication of geographic scope, then the court will determine the focus of the statute. If conduct relevant to the focus occurred in the United States, then applying the statute is considered domestic and it's permitted. If conduct relevant to the focus occurred abroad, then applying the statute is considered extraterritorial and is not permitted. US courts determine the geographic scope of federal statutes provision by provision. Because different statutes have different texts, different contexts, and different focuses, they may have different geographic scopes. So how does this all apply to the statutes under which Huawei has been charged? The relevant provision of IEEPA has a clear indication that it applies extraterritorially. IEEPA refers specifically to threats from outside the United States, and the provision on regulating financial transaction refers to foreign exchange, to foreign countries and persons, and to importing and exporting currency. The Iran regulations also interpret these provisions of IEEPA to be extraterritorial, and generally US courts will defer to reasonable interpretations of US statutes by administrative agencies. There's no clear indication of extraterritoriality in the statute prohibiting fraud against the United States, but conspiracy statutes like this are generally given the same geographic scope as the underlying offense. So if IEEPA applies extraterritorially, then the prohibition on conspiracies to defraud the United States by violating IEEPA would also apply extraterritorially. And there's also an old US Supreme Court case, United States versus Bowman from 1922, holding that statutes involving fraud on the US government are not subject to the presumption against extraterritoriality at all. The money laundering statute does expressly address its geographic scope. The statute says that it applies to foreign persons who commit an offense involving a financial transaction that occurs in whole or in part in the United States. And the charges against Huawei would seem to fall within this description. Interestingly, the bank fraud statute is different. US courts interpreting that statute have found that it has no clear indication of geographic scope. And turning to the second step, they have held that the focus of the statute is on the scheme to defraud a bank, and that there has to be some conduct in the United States that relates to that scheme. So far as I can tell, it does not appear that Huawei engaged in any conduct in the United States that's relevant to the bank fraud charge. So as a matter of US domestic law, I think Huawei probably cannot be convicted of bank fraud. But each of the other three statutes do clearly apply extraterritorially and can be used against Huawei as a matter of US law. So this brings me to the second question of whether the sanctions are lawful under customary international law. Customary international law permits exercises of prescriptive jurisdiction when there is a genuine connection between the subject of the regulation and the regulating state. And as Patrick has shown us on his slide, there are 6 traditional bases for jurisdiction to prescribe: territory, effects, active personality, passive personality, the protective principle, and universal jurisdiction. The key question is whether any of these bases would allow the United States to prohibit foreign parties from engaging in transactions outside the United States when the only connection to the United States is clearing the transaction through correspondent banks in the United States. Territory and active personality don't work because Huawei acted outside the United States and it is not a US national. Intuitively, effects seems the most plausible. The idea would be that Halkbank's actions outside the United States caused an effect in the United States, specifically the clearing of transactions or the use of the US financial system, however you want to characterize it. But customary international law requires that effects be substantial in order to justify prescriptive jurisdiction. And it's hard to see how the clearing of transactions in the United States meets that requirement. As Susan has pointed out in some earlier work of hers, the clearing does no harm to the US financial system. The clearing might make US sanctions less effective abroad, or prohibiting the clearing might make, allowing the clearing might make US sanctions less effective abroad, but that isn't a domestic effect. So it's hard to see what the substantial effect in the United States in this situation is. We might consider passive personality in light of the harm to US banks, specifically the fact that these banks may themselves be liable for violating US sanctions. I think the problem with this analysis is that the harm here is imposed by the United States itself. So this seems like impermissible bootstrapping, using a state's regulation of its own nationals to lay the foundation for regulating foreign nationals. And this is certainly very different from the circumstances in which passive personality jurisdiction has been recognized previously. The protective principle, to my mind, does not work either. Iran's nuclear program and its support for terrorism may well constitute threats to the national security of the United States, but that's not the question. The question is whether clearing transactions that have no connection to terrorism or Iran's nuclear program are threats to the national security of the United States. And finally, obviously, universal jurisdiction is not available because the clearing of transactions through the US financial system is not an offense like torture or genocide that is of universal concern. So I must conclude that the application of US sanctions to Halkbank violates customary international law. We need to ask next what the implications of that conclusion are for the validity of these charges under US law. And here you need to know a few things about the US legal system. First, it is clearly established that the US Congress has authority to adopt statutes that violate international law. Second, if a statute is not clear, it must be interpreted not to violate international law. And third, the president does not have the authority to violate international law on his own, that is, without the express authorization of Congress. If Congress had enacted a statute imposing sanctions on foreign companies acting abroad that result in clearing transactions through the US financial system, that statute would clearly be valid as a matter of US law. But Congress has not, in fact, done this. In fact, IEPA authorizes the president to regulate financial transactions only with respect to any person or any property that is, quote, subject to the jurisdiction of the United States, end quote. Now, it's not clear that Congress was referring to customary international law when it used the phrase subject to the jurisdiction of the United States. But it doesn't matter whether Congress was intending that or not. Federal statutes have to be read not to violate customary international law if it's fairly possible to do so. In addition, as I've mentioned, the president has no independent authority to violate international law. He can only violate international law if Congress has authorized it. So because the statutory authority for the Iran sanctions does not authorize sanctions that violate international law, any such sanctions are invalid. If the central charge against Halkbank of violating US sanctions is invalid, then the charge of defrauding the United States and the charge of money laundering must also be invalid. Each of those charges depends on the fact that Halkbank's conduct was unlawful because it violated US sanctions. And if Halkbank's conduct was not unlawful, if it did not violate valid US sanctions, then the fraud charge and the money laundering charge collapse. The same is not true for the bank fraud charges. US sanctions clearly do apply to US banks, and causing those US banks to violate US sanctions by concealing the transactions' connections to Iran would certainly constitute bank fraud. But as I've already concluded, under the presumption against extraterritoriality, the bank fraud statute requires conduct in the United States, and here there is none. So my rather shocking conclusion, or at least it was shocking to me when I reached it, is that all of the charges against Hauptbank are invalid. So in conclusion, I should stress the limitations of the analysis that I've just given you. First, I'm only talking about the application of US sanctions in these situations of correspondent account jurisdiction, where the only connection to the United States is the use of the US financial system. Second, this analysis only applies because the Iran sanctions have been adopted by regulation rather than by statute. If Congress were to adopt the same regulations by statute, or if it were to pass a statute expressly authorizing the president to adopt sanctions that violate customary international law, those sanctions would be valid as a matter of US law. And finally, the US presumption against extraterritoriality limits only one of the relevant statutes. The others have clear indications of extraterritoriality or are conspiracy statutes that take their geographic scope from the underlying offense. So I think it should be possible to challenge the application of US sanctions in US courts in extreme cases. And I do think that Hauptbank is an extreme case. But it's also important to bear in mind that most foreign banks will not choose to raise these challenges. They have already, and they will continue to settle charges like this, paying billions of dollars in fines, potentially, because what they really care about is maintaining access to US financial markets. And until US financial markets become less central to payments around the world, the United States will be able to continue to do almost anything that it wants to in this field. Thank you.
Thanks a lot to all presenters. So we now open the floor for a discussion. I think we have a good half an hour for questions and then answers by our panelists. So who can I give the floor from the audience, or perhaps from people on the chat? I don't know whether the chat is active. Yeah, I see a hand by Sasha Lohan. Sasha, you have the floor.
Yes, thank you very much. And I have to leave in 5 minutes, so I'm sorry to not follow the entire discussion, but I'm really happy, William, to hear you talk, because I have made this argument to actually challenge US law and US courts for a long time, and I have been actually actively encouraging US companies to do so, especially here in Germany, particularly with respect to a vehicle known as Instex, which apparently does not really have to lose any reputation anymore because it never had any. But as you said, it's really, really hard to do that. But we're talking about Iran here, right? So just imagine a more important market for European companies, for example, Russia or even China. I think this will change the calculation. But I mean, since I have the opportunity to talk to you, I will just really briefly ask you about your reading about AIPA, because I think that's really crucial here. And this somehow a little bit challenges what Susan has said. Because I also think that if you look at the legislative history of AIPA, especially a reading of Section 206, it suggests that Congress did not intend to criminalize extraterritorial acts and conduct by foreign persons who would engage in transactions involving any property that is subject to the jurisdiction of the United States, right? Because the regulation, and you pointed to that, pursuant to the AIPA, only apply to persons subject to the jurisdiction of the United States, and then I quote, with respect to or transactions involving any property in which any foreign country or a national thereof has any interest by any person, or with respect to any property subject to the jurisdiction of the United States. Sorry to be so really complicated. But, you know, the core of the issue is that Section 206, in connection with the enforcement section, 203 does not grant the president the authority with regard to transactions involving property, such as US dollars, subject to the jurisdiction of the United States, except for the sole purpose of blocking such property. And this then, you know, kind of does away with the correspondent jurisdiction. And I think this is the way to approach this issue with respect to banks that might be negatively affected in these really important markets, with respect to Russia, with respect to China. And the only thing that stands between us is the risk aversion and OFAC's, I would say, ungrounded kind of attitude or posture of never being challenged, although they really kind of go on really thin ice in this respect. And I really appreciate that you kind of somehow at least seem to share this interpretation. Thank you very much.
Sasha, as you have to leave in a few minutes from now, maybe Bill can first answer your question, and then I move to Stefan Kashuba. Bill, you have the floor.
Sure, thank you. And thank you for the very interesting comments. I think that, well, I should say at the outset, I am not an expert in US sanctions, and certainly not in US payment systems. Everything I know about US payment systems, I learned from Susan. But I think the provisions you were quoting from 206 and 203 are actually from the regulations in the Iran sanctions. The language that I was relying on in terms of what the statute authorizes is found in 50 USC 1702, which is the statutory authorization for these financial transactions. And I guess my basic point is that if the statute doesn't authorize it, and I think the statute has to be read to authorize only what's permitted by customary international law, then the regulations can't go beyond the statute as a matter of basic US administrative law. Certain authority is delegated to the president. The president has no other authority. If the president wants to enact other sanctions, he needs to have some statutory authority for doing that. And I don't see, I may be missing something, because again, this is not my primary area, but I don't see the statutory authority that would support it. So I do think that there's a possible challenge. You said the only thing that stands between us is the timidity of foreign banks. I think that's a very big thing. Foreign banks want access to the US financial system, and they're going to do essentially anything OFAC tells them to do in order to maintain that. I think Susan is raising her hand.
Can I say something to that? Swiss banks have a large and painful experience of what it means to be excluded from the US financial markets. When we harbored, some small Swiss banks harbored clients from the US who did not pay their US taxes, they thought they were shielded because they had no business in the United States. They did nothing in the United States. They went out of business within days after the indictment. So risk aversity is I mean, they just went out because nobody could, if you're excluded from the dollar market, you cannot exist as a bank. So it's big. That's what I wanted to say.
Maybe just one really quick follow-up. I'm also thinking about, settlements involving non-banks, which have been held liable for actions that were attributed to banks in the first place, but the banks weren't prosecuted. For example, Transtel in 2017. I think this is also a possible direction that OFAC is, moving towards, and I think this is then even kind of, more or further removed from the financial system. But it's just a really quick follow-up. And William, I referred to the statute, the 206 and 203 in NAIPA, but not the US code.
Thank you for your input, Sasha. Let's then move to Stefan Kashube. You have the floor.
We cannot hear you, or I cannot hear you.
Well, Stefan is trying to fix the connection. Are there any other questions at this point? Maybe from the audience present here?
Should I come to
Two co-organizers? Yes, yes, please come here. Yeah.
Yes. I had a question for Professor Dodge. My name is Nicolas Angelet from University of Brussels. Towards the end of your presentation, you said that the question is not whether the Iranian nuclear program is a threat to the security of the United States, but whether processing dollar operations on US territory is such a threat, right? And I believe that a few moments before you made the same reasoning regarding the effects doctrine. Now, I don't want to contradict you, but I think this is a vital issue, perhaps slightly counterintuitive, and I would like you to elaborate further on this. Why is it that the threat the Iranian nuclear program may pose to the United States is not sufficient as a basis for jurisdiction?
It's a very good question. I guess I think that in general, with respect to customary international law on jurisdiction to prescribe, we're looking for a genuine connection to the thing being regulated. So you have to think about what the thing being regulated is. And it seems to me that in these cases, it is the financial transaction or the ability of a US person to enter into a relationship with a non-US person that's being regulated. It's not directly what Iran is doing that's being regulated. And so I think that insight then has two implications, one of which is maybe helpful for those who want to challenge US sanctions, and one of which is not helpful. I think it helps support my argument that you need to look at these bases for jurisdiction to prescribe less expansively. So just because something might end up having an effect in the United States in some way if Iran decided to discharge a nuclear weapon in the United States, that doesn't justify all measures the United States would take. I think, though, that that same narrow focus might cut against some of the arguments that Patrick was making, because if I understood Patrick's arguments correctly, the basic thrust is that because what the United States is doing with its sanctions is trying to affect what non-US citizens outside the United States are doing, that is illegitimate, that itself is prescription. And under my way of looking at it, that's not right. My way of looking at it is what the United States is doing is territorial and national with respect to what happens in the United States and what is done by US citizens. So this narrow focus, I think, cuts both ways in this context. And I'm not saying that the way I look at it is necessarily the way everyone would look at it, but I think it is a very important question, and I thank you for raising it.
Patrick, I don't know whether you would like to react to Bill, because Bill was referring to your conception of access restrictions as, I remember well, territorial enforcement action, but extraterritorial prescription. So would you like to add to that, Patrick?
Basically, I would as Bill said, I would disagree with that viewpoint simply because I do not view the specific entry bans and the denial of access to financial commercial markets as prescribing behavior on US territory, but it is rather enforcement of the rules that the US has set for, as it states in its regulations, for foreign sanction evaders for conduct that takes place abroad. But even if you do not agree with that analysis, I would argue that irrespective of that, since the 1990s, a customary law in prohibition has come about that prohibits a state to use entry bans and the denial of access to commercial and financial markets as a way of enforcing its sanction laws. In more or less what Peter Fitzgerald said in 1998, he said a customary international law prohibition on the US practice of blacklisting was emerging. And 23 years later, I would say that prohibition is in place.
Great. Thanks, Patrick. Tom, would you like to take the floor now? And then we go back to Stefan the first time.
Well,
I can't hear anything.
Try again.
can you hear me now?
Yeah.
Okay, that's much better. So I was starting by saying that I much enjoyed the three presentations. So thank you to the three panelists. Two questions / comments, if I may. First question for Susan. You explained that in your view, it's virtually impossible to escape from, let's say, the grasp of US financial jurisdiction in a way, and that efforts to move away from US financial systems have been unsuccessful and are unlikely to succeed in the future. I was wondering, even if you would say hypothetically that there is a mechanism to escape from that jurisdiction, whether there is an additional layer of vulnerability on account of the use of financial messaging services. This is something that hasn't been addressed, but in Belgium, for instance, we have the Brussels-based company SWIFT, which is, of course, a key player in the financial messaging sphere, and which is also a vulnerable institution at that. So does that add to the problems which you have identified? And secondly, maybe a question for Bill. You discussed the need for a nexus under customary international law, including before US domestic courts. And I want to draw your attention to a case that you're undoubtedly familiar with, Arab Jesner, the case before the Supreme Court on the application of the Alien Tort Claims Act, where in the majority opinion, Justice Kennedy also seems to suggest that mere clearance through a US-based dollar correspondent bank account doesn't really create a nexus with the United States. And I'm quoting from the ruling, the clearance activity is an entirely mechanical function. It occurs without human intervention in the proverbial blink of an eye. There is no dispute that the speed and volume of these transactions are such that individual supervision is simply not a systemic reality. Do you think that this would provide munition if one were to contest before a low US court the legality of, let's say, correspondent account jurisdiction in a case such as one you've discussed? Thank you.
So who would like to go first? Susan, you unmute yourself, so you have the floor.
Okay, thank you, Cedric. I'm not sure if I heard everything. It was sort of a little bit far away, but your question was if the use of financial messages services like SWIFT, if it adds to the problem or not. If that is the question, it does add to the problem in a sense that those SWIFT messaging instructions, which used to be which used to be a private service offered to the banks for better functioning, have now reached a role of as an instrument in anti-money laundering. So the whole travel rule in anti-money laundering is now relying on those SWIFT messages. So the information that you include is not just something that is just not mandatory. It's become mandatory. And so I think it adds to the problem, at least when we look at direct financial use of the payment system, or even indirect. Now you're actually, because it's part of the anti-money laundering efforts, it becomes even worse in parentheses. But I'm not sure if I really understood your question, but that would be my answer to it.
Thank you. Bill?
Yes, so I am familiar with the Jesner case and the Alien Tort Statute. I think that the United States, in briefing that case, the US amicus brief on behalf of the government, tried to distinguish between what would be relevant contacts for purposes of asserting criminal jurisdiction and what would be relevant contacts for asserting civil jurisdiction, or jurisdiction with respect to a civil statute. And the court didn't end up discussing that distinction. I don't really believe in that distinction, but the US government at least was careful to try to preserve jurisdiction based on correspondent accounts in the United States in the criminal context. I guess my other reaction would be that I think Justice Kennedy's statement in Jesner, I don't think was talking specifically about customary international law. The Alien Tort Statute is a very complicated statute. It's got a complicated jurisprudence that the Supreme Court has developed over many cases. And I think he was talking about it in the context of the implied cause of action under the statute. So I don't think one can make a lot of the quote in Jesner. One can certainly try, but I don't know that it would be very convincing to US courts, at least.
Thanks a lot, Bill. Stefan Kashuber, have you been able to fix your connection? Let's try again, or perhaps you have to remove your headset. Maybe that's the problem.
Well, I hope so. Can everybody hear me now?
Yes. Go ahead.
Perfect. Well, that's great. Well, first of all, thanks to all three for the very interesting presentations. And I have a question for Professor Emmenegger. I really liked your presentation and, of course, all of your other works regarding the topic. I really enjoyed reading them. And I have a very specific question which may go a little bit in the direction of what Tom just asked. So when following your presentation, I had the impression that it's the whole matter of currency jurisdiction, so to speak, is very much connected to the, let's say, the technical process of clearing an electronic transaction. So my question now would be, do you see any basis in international law for making the currency itself, or using the currency itself, a basis for a state to assume jurisdictions? To make a very practical example, let's say we disregard all electronic forms of transactions and we just have US dollar bills, and then some nationals of foreign countries trading or exchanging dollar bills for trade on the soil of a foreign country. Would you say there's any basis for the US to assume jurisdiction over such transactions, because simply the US dollar as a physical currency is involved there, and so we have this connection to the United States? Or would you say this is completely baseless in under the rules of jurisdiction or under international law in general? Because it might seem as just an academic example or question, but it might gain relevance because there are still some countries apart from the US, which have the US dollar as a currency, or criminal organizations might take advantage of just handling cash transactions and not using electronic transactions at all. So, yeah, I'd like to hear your opinion on that. Thank you very much.
Just using cash, does that make a difference? Susan, what's your view?
Yes, it does. I would, under international law, I would definitely say it does. There's actually a very good publication by Bismuth. I don't remember his first name. but he's written extensively, or not, he's written on that, and I share his view that the lex monetae, how you call it, does not confer a state the power to exercise jurisdiction over transactions involving the currency. So our problem today, as I should put it, is that we have cashless transactions which use the clearing systems in the United States in one way or another, and they touch. But I would say under international law, and even there, I would actually say probably even a US court would not see enough of a territorial connection if only money is used abroad for, at least for sanctions. Now, our problem again is that we have you got me thinking about something. It's really this anti-money laundering where you say, well, this is a criminal act, and now that's a money laundering if you use that. So it might be getting back into the jurisdiction with this money laundering statutes. That's really something I would have to look at again. But traditionally under international law, and even I would say national law, if it's just the use of money, then it should not suffice. But I'm now more and more worried about money laundering and the anti-money laundering statutes. At this point, let me add that American anti-money laundering, the law since 2020, I think, requests all banks who have a correspondent account to actually notify when they block the transaction, even in their country, for sanctions or other US relevant acts. So that's really like another box that's just awaiting there that I haven't tackled yet, but I'm worried.
Can I jump in on that as well? I want to strongly agree with Susan and Reggie Bismuth. I don't think the use of a US currency establishes jurisdiction to prescribe. It's important to recognize, though, and the US Treasury officials say it does not, too. They say you can use US currency outside the United States, and that's not a violation of US sanctions. The US does prohibit some transactions in US origin goods and technology outside the United States. I think that's also not permitted by customary international law, because goods don't have nationality unless the United States imposes conditions on their export that they not be sent on to other countries, which many countries do. The US can't control where they go. But I could see an argument by an analogy to what the United States does in goods, that the US could start adopting sanctions based on the use of US currency. But currently it does not understand its sanctions to apply in that situation. And I agree with Susan that it would violate customary international law to do so.
Stefan, are you satisfied? I still see your hands there. Would you like to react to that?
That was just an accident. No, I left it on by accident at the end. But thank you all very much for the very interesting answers. Thank you.
So the Mr. Bismuth reference to whom was made is Regis Bismuth, indeed. Are there any other questions from the audience? So then I would like
I can jump in because Antonius had made a remark that we were interrupted, or I mean, we wanted to start with the conference, whether the EU is not moving in that direction by making applicable, for instance, in the draft for directors' duties, that EU directors' duty legislation, or this regulation that the EU Parliament proposed, will apply whenever you do business in part in the EU. And my answer to that is yes, that can become an extraterritorial application. But if we keep within the international customary law that we say it has to be a substantial part, then I don't see that the EU would be moving in the same direction. But yes, there's a chance, because I think the EU has certain topics, sustainability, director's duties for social, environmental, and governance topics, where the EU wants to set the worldwide standard and wants to be the motor and wants it to be enforced everywhere, or wants it to be implemented everywhere. So we just think that well, I'm not even in the EU, but just think that we are the good guys in that. But of course, the US perspective with the sanctions is the same. So, but the EU has those types of extraterritorial inklings, I would say, and we don't know where that goes. So that's my answer to this.
We don't call it extraterritoriality, we just call it territorial extension, following Joanne Scott's typology, and then there's called no problem because it's all covered by the old.
Could I react quickly to what Susan was so nicely referring to, the question we talked just before? I'm referring to a clause in EU sanctions regulations, where the EU says that its sanctions regulations apply also to any legal person, entity, or body in respect of any business done in whole or in part within the Union. And this morning, Martin Vogt also referred already to this clause and say this makes it even more complicated. And interesting is, you can say customary law says it has to be substantial, but what does this mean? Does the action to be substantial to the contract or to the business or to the gross national product? It is of course not clear what it is. Is it substantial to the effect that it has? Does it have an effect to, let's say, undermining the EU sanctions? My interest in this case is saying then that is something for this meeting. We are so much looking at what the US is doing in terms of extraterritorial or secondary sanctions. And I've doing some investigation in this field and say, how much is the European Union going itself already in this direction? And this morning, I think Tom referred also to it, that in the case of the sanctions against Belarus, and then going after air transport companies or air agencies in Iraq, in Turkey, in Lebanon, and saying, if you go on by playing the game of Mr. Lukashenko, we will sanction you, which is clearly saying, if you help the primary targets, we go after you as secondary targets of our sanctions, because anyone who aids and abets or supports the targets of our sanctions. And I think this is important because, as I was mentioned this morning, in fact, the blocking statute is only applicable to US legislation. Although the Commission speaks in its initiatives about certain countries, but in fact, it has only been US legislation. And therefore, I think the EU should do well, and that is something I have already written to the Commission, say you should do well to really find out how much of these secondary sanctions of the US are really, let's say, not compatible with customary law, apart from sanctions law. And you should also look at yourself as sanctions authorities, especially that CFSP sanctions becoming much more popular, and which extent the European Union does a little bit in a different way from the United States, but also says anyone, a company that aids or abets, or person aids or abets the persons that we are targeting with our sanctions, and thereby undermining the effectivity of our sanctions, we will put you also on the sanctions list. Quite frankly, in 1989, I drafted a regulation against the Milosevic and said, it is not only the government of the Federal Republic, any company owned or controlled by Milosevic, even any company outside the Federal Republic of Yugoslavia, which is owned or controlled, they are all targets of our sanctions. That is mixing up, and it was also mentioned this morning, I think, with the lady and for the humanitarian aspect, to say we got a complete confiscation in the European Union, saying which are the primary targets, which are the secondary targets, but the secondary targets, like the primary targets, are in fact secondary measures, extraterritorial measures. Sanctions are by definition extraterritorial. You don't need to say extraterritorial sanctions. They are having and are meant to have an effect extraterritorially. What they're doing it mostly exactly like the United States does by prohibiting, restricting access to the territory, access to the means, to the finance, and so on. So we have tomorrow also and this afternoon, but I think it is wise for the European Union to be aware of its own sanctions practices, which are getting closer and closer to that of the United States, I guess. Thank you.
Thank you. Territorial versus extraterritorial, and a call to action that you should also look into the mirror. Let's also look at ourselves. So I would like to end the panel.
I would just quite like to respond to that quickly. Yeah, just quickly. I think that that's a general tendency in international law. I mean, basically, if you can't beat them, join them. And since it has not been possible to convince the United States of moderating its sanction policy, the European Union, that has become more important in international trade, will adopt similar policies. And I think that will happen more and more. And I think the big danger for all of us that China will probably follow suit. It has already followed suit with the blocking statute, which is introduced earlier this year. And I think they will presumably go on to start imposing secondary sanctions, very likely in response to, relation to Taiwan. And in my view, that's the bad example sort of taking over. And that has happened with the use of force. And I think we're now seeing it in this area as well.
Thank you for that addition, Patrick. So many thanks to all of you, to all our panelists for their excellent presentations and participating in the Q&A, and for everyone